Dear ladies and gentlemen, welcome to our next day of very interesting conference. Yesterday we had a full of debates, a full day of questions, answers, discussions. It was really nice in my opinion. I hope it was your opinion too. And now we have the next day. I hope it will be in the same spirit of questions, answers, very interesting presentations by our speakers. So my name is Vladimir Gross. I come from Moldova State University. I was asked by our colleagues to moderate, to preside this morning session. As we see in our agenda, we have also, like yesterday, very interesting topics of presentations. So we have Nina Kršljanin from University of Belgrade, who will speak to us about Novorossiya, Malorossiya, very interesting issues which evolved during last years. Yeah, we'll have our colleague Dragoljub Popović, professor from Belgrade University, who will speak to us about Minsk Agreements. Yeah, also very actual in the mark of last events in Ukraine this year. And we have with us Mr. Ivan Bunik, a professor from Genocide University, who will speak to us about the status of Donbass region. So very interesting topics. I hope we will have very interesting discussions. So we have very strict timetable. So everybody has, from our speakers, will have 15 minutes, at most plus 5 minutes at most. So I ask you to follow this very strict timetable, and I will ask our first colleague, Ms. Nina Kršljanin, to make the first presentation, please.
Thank you very much, dear Chairman. Thank you all for coming. The students know that during our autumn school, we had a lecture on the history of Russian and Ukrainian relations, where we went back from the founding of Kyiv until present day. And this will be a sort of a zoom in on an issue related to that, on the regions that used to be called Malorossiya and Novorossiya, so Little Russia and New Russia, how those regions over time became Ukraine, and how some people attempted to restore them and why. Let me just check how to use the slides. There it is. Sorry. So the first of the issues that actually appears in history is Velika Rossiya, Great Russia, Big Russia, and it appears in various 12th century sources, from Russian chronicles to French epics, to even one of Snorri's Swedish sagas, where Russia is referred to as Sweden the Great, because obviously it was ruled by Varangian, Viking, practically Swedish rulers. And essentially that was an on and off designation. When that term starts having some sort of legal meaning is in the context of ecclesiastical law in the 14th century. I'm very sorry that our colleague Dalibor Đukić has fallen ill and that he won't be talking about the ecclesiastical issues afterwards. But either way, in the 14th century, when the seat of the Russian Orthodox Church moved from Kyiv to Moscow, the Greek Church, the Ecumenical Patriarchate in Constantinople, started referring to two Russias, the Little Russia and the Big Russia, Mikhail and Megalorossiya, meaning in fact the territory of the eparchies of those two metropolitans. So the one that was originally the Metropolitanate of Kyiv, which is now no longer the head of the church, is the Little Russia, and the one that is in Moscow and that covers the territories in the northeast roughly is the Great Russia, the Big Russia, and we have various acts from the 14th century, referring to those two territories in this way. Now, what was the reason? There are two territories, two main reasons that are being named. Now, this map is from the internet, and as you can see, the borders are drawn really approximately. So, of course, they weren't such straight lines. It's not the colonial division of Africa, but this is approximately what the territory is referred to. One theory was that as even in ancient Greece, some colonies were named Great, the same thing, the name of the home polis, and you remember we had Magna Graecia, the Greek colonies in Italy. But the problem with that theory is that the home territory was never referred to as small. So the others were referred to as the great, the big, but that did not lead to the diminishing of the home territory. And the other theory is that it was simply a matter of geographical size. And if you look at the map, well, that one seems pretty logical. And similar naming conventions were used in other countries at the time as well, particularly in Greek sources, but also, for example, in Poland. So some part of the territory was referred to as small, some as great, Scythia, Poland, Hungary, whichever, and probably from, let's say, from the southwest, that convention of naming came into Russia and started being used not only in the ecclesiastical context. And we can see in some old maps, these are 17th century maps, that the name of the Great Russia or Big Russia was frequently used for the country. So we have here, I don't know how much you can see it because it's over all the geographical points, but it's Moscovie, Grande Russie. This is a French map, and this one we have in Latin, Moscovie, Russie, Magne. So that was logical that was the big Russia, also the one that had state sovereignty. Now, let's return to this map before people drew those things on it. This is actually the map of ethnically Russian lands at the end of the 14th century. You can see the various principalities in Russia that will later be united under Moscow. You see the Grand Principality of Moscow in green, but also the big country you see in the southwest is the Grand Duchy of Lithuania, soon to be joined with Poland into the Commonwealth and to become even larger. And as you can see, the old territories of Little Russia, of the original Kiev and Rus, are under the Lithuanian rule, so it all started with the weakening after the conquest of the Golden Horde, and then the Lithuanians came and conquered those territories. So now not only were they divided in an ecclesiastically administrative manner, but initially a part of Russian principalities, they were now in two different countries. And that was a big factor of change. So the so-called Little Russians were now living under foreign rule, which was initially not drastically different from their previous conditions. It was similar to, say, a foreign prince coming to the throne, but gradually the conditions worsened, particularly when Poland came into the equation because of various factors, including religion, because they imposed the Catholic faith. That was when the Uniate Church was formed, the later Greek Catholic Church of Ukraine, and so on. What we have here now is, again, the middle of the 17th century and the uprising of Bogdan Khmelnytsky, the hetman, the leader of the Cossacks of Malorossiya, as they still referred to themselves, who led an uprising against the Polish-Lithuanian rule, starting in Zaporozhye, out there in the southeast, and who liberated or conquered, depending on your point of view, a part of the territory, and then petitioned repeatedly the Russian Tsar to accept them under their rule, which the Tsar finally did. And from that point on, this region returns to Russia, but that is not the entire territory of what used to be Malorossiya. We can see later in the 18th century, under Catherine the Great, how the conquest was continued, and you know that Poland was divided between Russia, Prussia, and Austria, and Catherine managed to restore most of those lands under Russian rule, though not all of them. We see a significant part that is colored in orange here that went under Austrian rule, that the center there was Lvov or Lviv, and that is in fact what's today's Western Ukraine. And the situation in Austria in the terms of national freedoms, the right to use their own language in education, religion, etc., was probably even worse than it had been in Poland, Lithuania. Now, how did that Malorussian identity develop? Essentially, they saw themselves as Russians, but they still saw themselves as somewhat different. Of course, in the pre-modern era, we don't have the concept of national identity as such, but we do have the bonds of common language and common religion. And we have, in the 16th century, papal nuncius mentioning that the population of Little Russia sees themselves as one with the Russians living in Muscovy because they speak the same language and they are of the Orthodox Christian faith. However, the language began being influenced gradually by Polish. Some of the communities of those people converted to the Catholic faith. The situation was gradually getting more complicated. Now, at least for those that were now a part of the Russian Empire, they saw themselves as somewhat apart, but generally as a part of the same people, though gradually a different sort of nationalist tendency will begin to appear. What we have here are simply two examples that show how the words were used. One is the Russian dictionary by Vladimir Dahl from the 19th century, which is given as the dictionary of the living Great Russian language, in the sense that it's the Russian that's spoken on the territory of the Great Russia, not the Malorussian version, which is linguistically different. So it was simply a designation. And we have here a quote from Gogol that I didn't mention to find in English, who is talking about the need to support a unified language for all the lands, that the Russian literary language, the language of Pushkin, should be the one language for the Russians, the Czechs, the Ukrainians, and the Serbs, which is interesting. But he says the Malorussians and Russians, so he doesn't say Great Russians, need a single poetry, calm and strong, a poetry of justice, goodness, and beauty. Russians and Malorussians are twin souls which complement each other. They are related and equally strong, and to give support to one before the other is absolutely impossible. This is a much simpler map, but I found that one in English. So this, what you see up in the north, is that Little Russia after it was returned to the Russian Empire. So this is the map of the late 19th century Russia. The territory that is pointed out in yellow is the so-called New Russia, Novorossiya. That territory used to have a completely different name, Дикое поле, wild field. It was essentially a sparsely inhabited steppe that was the borderland between the Malorussian territories and the Crimean Khanate in the south. That sometimes was used as territory for raids and so on. And as the Russian Empire strengthened, it conquered that territory and started building there with great intensity. So new cities, industry, and everything was built there, and it became a very prosperous part of the country. And that's the one that also in the 18th century contained the regions called Slaviana Serbia and Novoserbia, so the places where lots of Serbian immigrants were living. And then we have Crimea, which was also finally conquered under Catherine the Great. So the Crimean Khan sort of accepted an abdication and acceptance into Russian rule. And then, of course, it became a strategically important area due to the access to the Black Sea, but also culturally, touristically, a fashionable resort area and so on. And there we had mostly the Tatar population and the Russians who came after the conquest. At first there wasn't much mixing due to cultural and religious differences. Gradually, of course, that changed as we go into the contemporary history, and those people generally perceived themselves as Russians. Now, what about the name Ukraine? Ukraina initially meant borderland. So we can see two medieval, one earlier, one later examples of the word Ukraina in Russian chronicles. One is referring simply to a borderland, a certain prince's country that wept after his death. And the second, which shows us that the word was initially used generically, speaks of a foreign prince's promise not to harm the great Prince Vasil and his son Prince Ivan and their Ukrainas, their borderlands. So there won't be any attacks, there won't be any raids against your borderlands, against the parts of your country that we are bordering with. And there's also a folk song speaking of a Siberian Ukraina, so it obviously, in those old sources, it cannot refer to the territory of contemporary Ukraine. It was a generic term denoting a borderland, and the territory of the former principalities of Kiev, Galicia, and so on was precisely that for old Russia. However, that gradually changed as the territory stably was probably the most important borderland. It began to be constantly referred to as such, and what was at first a generic designation started becoming a given name. We again have some interesting maps that now use the word Ukraina, or in this case, Ukrania, but well, foreigners sometimes mix up letters. So the name began to be used particularly for that region. Again, we have some yes, this one's Ukraina, sorry. So we have two different identities for the people of the same region starting to show up. The people that you have here, I put down their names because you probably don't know them. I presumed everyone would recognize Catherine the Great. But these men, Mikhail Gilshevsky and Linichenko, were In the 19th century, the two late 19th century most prominent historiographers of opposed views. So Gilshevsky was an Ukrainophile. He talked about Ukrainian national identity as separate. Linichenko insisted on Malorussian identity, that they were in fact Russians, that it was the same people, etc. Gilshevsky had a turbulent, not only scholarly, but also political career. He was at the time president of the Rada when the Soviet Union was unified. He was accused of being a traitor for a while. He ran away, then he begged them to come back. He managed to win his way back into the good graces. He became a member of the Academy of Sciences and a fairly important person, while Linichenko lived in southern Novorussia and Crimea for the most of his life in relative poverty and wasn't particularly important during the Soviet period, which is all related to the fact that the Soviets insisted on Ukrainian identity, so not Malorussian. You know that generally communists in Yugoslavia as well were great supporters of federalism, of national particularities, and so on. They insisted on this too. Now, this is a rather provocative map that's been swimming on the internet lately due to the current war, in which the territories, as they were chronologically added to Ukraine, are referred to as gifts of various Russian and Soviet leaders. But despite that dubious formulation, it does show the truth geographically. So what was the Cossack Malorossiya, the Ukraine that initially joined Russia in Bogdan Khmelnytsky's time in 1654, is shown in red. Then it was gradually broadened to the territories that were taken back from the Polish-Lithuanian Commonwealth and Poland when it was divided. Afterwards, the former Novorussia was also added in the Soviet Union as it was formed in 1922. After World War II, finally the territories that were in initially Austria, after World War I in Poland, so the westernmost Ukraine, were added to the Ukrainian Soviet Socialist Republic naturally. And finally, in 1954, Khrushchev added Crimea due to the fact that it had geographical and economic connections, though it is interesting that right before the Soviet Union fell apart, there was a referendum in Crimea showing that the people wanted to be an autonomous republic again, but that never happened. And finally, this is my last slide. There were two projects during the current war of the people mostly in the Donetsk and Lugansk republics that tried to create a confederation of those two self-proclaimed republics that would be initially called Novorossiya, and the first flag you see was one of the variants for the Novorussian flag that was suggested. That project fell apart after about a year of talking about it. Then in 2017, another idea of having Malorussia again was proposed, and they wanted to use the flag of Bogdan Khmelnytsky from the 17th century that you see here. So those were all references to old historical identity. At the time, the official government of Russia did not support these projects, and they simply ended in nothing. Now we see that the Russian government has at first confirmed the statehood of the Donetsk and Lugansk republics and others, and then has integrated them into Russia. But again, these namings were not used. They were still integrated as the Donetsk National Republic, etc. So why? why did they not support the idea initially? Well, perhaps because they thought they'd settle the situation peacefully through the Minsk Accords, which Professor Popovic will talk about later. But why didn't they use those names even after they've decided to go all the way and accept those territories back into Russia? Well, one possible option could be that essentially the Malorussian identity was the weakest of those living in those territories. Yes, historically educated people know of what the region used to be called, but most of them don't see themselves as Malorussian anymore. They see themselves either as Russians, the same ones as those living in the Russian Federation, or as Ukrainians. And maybe it could be that using those names would be too reminiscent of the old Russian Empire, because they were created in that period, and the modern Russian Federation builds itself on different principles than the old Russian Empire did. This is not a final conclusion. If there are any comments, particularly from our Russian colleagues, I will be very grateful if anyone sheds more light on the issue. Thank you for your attention.
Thank you, Nina, for clarifying these issues. Very interesting. I like a lot maps, geography, history too. So it was very interesting for me. So that's why you had 3 minutes more. So
I'm sorry.
No, it's very interesting because from my point of view, so I'm from Moldova. My country assisted at the beginning of the finish of the former USSR, and my country comes from USSR. And from my point of view, Russian Federation after 1991 always tried to build some project, doctrinal project, ideological project, to take again together all of these former Soviet Union countries. And the first project, it was community of independent states, which reunited, kind of political project which reunited the former Soviet countries except Baltic states. But now, I do not know, at least from 2013, 2015. So this project doesn't work in practice concerning Moldova, Russia, Georgia. And we can see other projects, other ideological projects are launched by Russian Federation, like Ruski Mir, Russian world, like Nouvelle-Russie, Novorossiya, Malorossiya. It's interesting to follow up all these ideas, how it evolves in the space and in time. Thank you. Please note your questions after all the key presentations will be presented to discuss in details. And now I will ask our good colleague, Mr. Professor Dalibor Popovic, University of Belgrade, to make a very interesting presentation on the Minsk Agreements from 2014-15, how they will change the situation. And please begin, Mr. Professor.
A Swiss diplomat and former Secretary General of the OSCE, Thomas Greminger, stated in an interview for the Austrian daily Die Presse that the war in Ukraine, and I quote, could have been avoided, unquote. It was in October this year. Greminger held his position within the OSCE from 2017 to 2020 and was involved in the activities of that organization, which had been aimed at the preservation of peace in Ukraine. The peace, no matter how fragile, could have been secured by way of implementing the relevant international instruments that had been designed to serve its cause. These instruments were the Minsk Agreements. The Minsk Agreements 1 and 2 were the outcome of diplomatic efforts performed within the so-called Normandy format, which included France, Germany, Russia, and Ukraine. To be precise, however, the negotiations leading to the conclusion of the agreements were held between the Ukrainian government and the representatives of the insurgents from the Donbas region. The Russian government and the OSCE were only facilitating the negotiations. France and Germany somehow stood behind them without immediate participation. The Normandy format has been criticized among commentators for relying on the false premise that Russia was a mediator and not a party to the conflict. The complexity of the issue was reflected by the signatures. A Swiss diplomat, Heidi Tagliavini, signed on behalf of the OSCE, along with the Ukrainian representative, former President Leonid Kuchma, the Russian ambassador to Ukraine, Mikhail Zurabov, and the two insurgent leaders, Alexander Zaharchenko and Igor Plotnitsky. The substance of Minsk I and II agreements differed in the sense that what Minsk I provided in its item 3 was developed by the items 4, 11, and 12 of Minsk II, as far as the political and constitutional settlement were at stake. The constitutional repercussions of Minsk I and II agreements for Ukraine are the only topic of interest in this paper, because there are others. The Minsk I agreement, concluded in September 2014, provided for decentralization of power in Ukraine, which was to be based on a special piece of legislation adopted by the Ukrainian parliament. The idea was to create a special status for Donetsk and Lugansk regions. Minsk II agreement, concluded in February 2015, went further on, following the same path. It provided in item 4 on the elections that were envisaged in the regions of Donetsk and Lugansk, specifying the time frame for them, as well as some other important details. In item 11, Minsk II document provided on, I quote, constitutional reform in Ukraine, with a new constitution to come into effect by the end of 2015, end of quotation, the kernel of which was decentralization, introducing special status for Donetsk and Lugansk. In addition, item 12 envisaged that questions related to local elections shall be discussed and agreed with the representatives of the two regions so as to enable elections that would fit the OSCE standards. The Minsk agreements had a poor destiny. They proved inefficient. The elections were rescheduled several times. The two sides were unable to agree on many issues concerning them, so that once held in the regions of Donetsk and Lugansk, their results were not universally recognized. The Ukrainian government on one side and the regional authorities backed by the Russian government on the other exchanged reproaching statements, blaming each other for the failure of the agreements. It is not the purpose of this paper to research whether one or the other side was right or wrong. What is essential is the fact that the occasion had been missed to carry out the plan which might have preserved the peace. The war broke out instead. And now we are facing the idea of the restoration of peace as features marking the situation in the embattled country of Ukraine, which was attacked on the 24th of February 2022 by the Russian troops. Three main issues can be identified if we are to search for peace. These issues concern territory, security, and constitutional settlement for Ukraine. The territorial issue comes first. As of February 2022, the Russian troops took hold of a good portion of the Ukrainian territory in the east and the south of the country. To this should be added that the Crimean Peninsula had been annexed to Russia as of 2014, the fact which indeed provoked the whole crisis and led to the concluding of the Minsk Agreements. A referendum was organized back in 2014, the result of which was the unification of the Crimea with Russia. The pattern was repeated in 2022 for 4 regions belonging to Ukraine. Referenda took place not only in Donetsk and Lugansk, but also in the regions of Kherson and Zaporozhye, while the warfare has been still in course. Needless to say that the results were favorable to the goals of the Russian government. Russia proclaimed annexation of the 4 regions on the basis of the referenda results. Now, on the account of the Ukrainian government's statements, the war goal of Ukraine is to liberate the whole country, including Crimea. It has been remarked among authors who treated the issue that such a goal does not seem to be realistic. It is also considered problematic whether the Ukrainian army, despite fighting bravely against the invasion, could be in the position to liberate those parts of the Donbas region that have been under the insurgents' control already as of 2014. A moderate opinion on the issue, expressed by experts, both with Russian-Ukrainian roots, but working in Canada and the US, supports the thesis that an effort should be made to reintroduce on the ground what was labeled as a status quo, which existed before the 24th of February 2022, so as to provide basis for negotiating peace between Ukraine and Russia. This sounds fair enough, but the question of the feasibility of such an idea remains nevertheless open. The security issue has another dimension which is prevailingly international. It concerns the topics regarding the balance of power at the global level. It has been remarked that the existing rather restrained diplomatic contacts between the USA and Russia represent a threat to the stability and the world peace. Nota bene, there have been some contacts in Istanbul some days ago. The security issue includes questions of a wider scope. Such questions are, for instance, the future relations between Russia and the West, it was mentioned yesterday, and also the efficient guarantees of Ukrainian security. Although the security topics are tremendously important, they do not represent the main interest of this paper, which concentrates on the discussing of a future constitutional settlement for Ukraine. And now we come to the constitutional settlement. As mentioned above, Item 11 of the Minsk II agreement provided for a constitutional reform in Ukraine and consequently for the adoption of a new constitution based on decentralization of the country. The current constitution of Ukraine, as revised in 2019, provides in Article 2.2 that Ukraine is a unitary state. Despite such a provision, however, the Constitution provides in Articles 134 to 139 for the Autonomous Republic of Crimea within the unitary state structure. The territorial organization of Ukraine is laid down in general by Article 133 of the Constitution. The country consists of the Autonomous Republic of Crimea, 24 regions, oblasts, enumerated by the article, as well as of 2 cities, Kiev and Sevastopol, enjoying special status. The text was drafted and adopted in the revised version under the assumption that both Crimea and Sevastopol were under Ukrainian control. Putting together Articles 2, 133 and 134 to 139 of the Ukrainian Constitution, the impression is at first glance that on the one hand, the provisions of Article 2 and 134 to 39 are comparable to the British unwritten constitution after the devolution of the 1990s. A unitary state has a separate part with its own government and competence, like for instance Scotland or Northern Ireland in the United Kingdom, that is for the Crimea. On the other hand, Article 133 of the Ukrainian Constitution reminds of Russian Constitution. In Russia, the territorial units are 83 in number, most of them called oblasts. The 2 largest cities of the country, there is also a parallel, enjoy the status equal to those of oblasts, Moscow and St. Petersburg. There is nevertheless a significant difference between Russia and Ukraine in terms of state organization. The former is a federation, the latter a unitary state. It occurred to the drafters of the Minsk Agreements that introducing a certain degree of decentralization of Ukraine might serve as a solution to the problem between two neighboring countries, which, as we have seen, are similar and connected in many ways. The sequence of events deprives us of the possibility to check the veracity of such a belief. We do not know what might have happened had the provisions of the Minsk Agreement been carried out. At the same time, it seems likely that the question of constitutional reform and decentralization of Ukraine may reappear on the diplomatic agenda. This justifies an effort to conceive a possible direction and shape of reforms of the Ukrainian constitutional settlement within the framework of the future peace process. Treating topics like the one that is under discussion in this paper may take an attitude expressed by Amin Maalouf, a French writer of Lebanese origin, currently occupying fauteuil number 29 in the French Academy, as a starting point. Maalouf raised an important issue concerning the scope of action of a nation state. His question was whether nations should act exclusively according to their own interests and ambitions if they were to pursue a path advancing the humankind toward peace and prosperity. His answer was in the negative. It is in a book which has a significant title, Le naufrage de civilisation, the shipwreck of civilizations. Maalouf's fundamental idea consists in overcoming national, tribal, ethnic, or communitarian egoism, that is, a group egoism of any kind. It must be replaced by mutual respect of all nations and actors at the international scene, representing their nations, states, governments. The main features of such an attitude lay in its universality. What applies to one should inevitably apply to the other, and indeed to everyone. Quoting Maalouf here is by no means aimed at calling for any sort of concessions one or the other side in the Ukrainian war conflict should be invited to make. Neither has it any intention to suggest a certain pattern for the political and constitutional settlement of a sovereign nation, such as Ukraine. Overcoming egoism moderates, however, the approach to the problems the political actors are dealing with. And now you will tell me that I finish my paper where you expected it to begin, but I did it on purpose because it is for the Ukrainians to decide on the constitutional settlement of their country. However, in an academic atmosphere, we could raise certain ideas, questions, and discuss the issues among us. Thank you, Mr. Chairman.
Thank you, Professor. Very interesting presentation. Surely it's for Ukrainians to decide their constitution and what sense to change it, but it's for us also to debate these issues, really, because it concerns our countries too. How to manage, how to change, or how to adapt our constitutions of our country, depend and take into account foreign experience of other countries. Thank you, Professor. So please note those which are interested in the presentation of Mr. Professor Popovich later to address the questions. And now I will ask our third key speaker, Mr. Ivan Bunik, MGIMO University, who will speak to us about the status of Donbass. Please begin.
Good morning. My name is Dr. Ivan Bunik, and it's my honor and privilege to speak to you today. Let me start by thanking the University of Belgrade and its Faculty of Law for organizing this conference. Today I want to speak about Donbass and compare its legal status to other similar cases in international law. My goal is not to defend any political position or justify any party's actions, but on the contrary, to reveal the bias surrounding the legal interpretation of events. Analyzing the latest armed conflicts, nation-state question is one of the main underlying reasons for hostilities and tensions. For example, one of the factors behind the recent violence in Iraq is the sectarian divide between Sunni and Shia Muslims and the challenges linked to their cohabitation in one country. The Yugoslavian conflict of 1999 was accompanied with clashes between Kosovo Albanians and Serbians. The ethnic minority of Catalonia has also invoked the national issues with regards to Spain. This underlying national reason for such conflicts raises the issue of their consequences under international law. In this context, lawyers need to determine whether a particular nation constitutes a people and whether it has the right to self-determination as provided in the United Nations Charter. The question of Ukraine, Donbass, and Russia, therefore, should be analyzed from the following points. Do Donetsk and Lugansk really have the right to self-determination by creating a separate state? And how can Russia's actions of providing military assistance to Donetsk and Lugansk be interpreted under the applicable international law? Let us now consider the relevant case law of military interventions, the reasoning of the countries involved in such conflicts, and the reasoning behind the cases of alleged self-determination of peoples. One of the examples to be critically assessed here is the military intervention of the United States into Iraq. First of all, the United States, represented by its State Department legal advisor, claimed that Iraq has violated the ceasefire established by the Security Council Resolution 687 of April 1991. These violations were confirmed by another Security Council resolution of 2002. The latter indicated that the continuation of such actions by Iraq would lead to serious consequences. Many scholars argue that this wording is different from, for example, the resolution on the use of force for the liberation of Kuwait in 1990. In Kuwait, Security Council called for the member states to use all necessary means to implement it. Besides, some researchers invoke Article 60 of the Vienna Convention on the Law of the International Treaties, which allows for the termination of a treaty in case of a material breach. They state that this article could not be used here to justify the United States actions because of the UNSC resolution on ceasefire is not an international treaty. As far as the situation in Ukraine is concerned, Russia's representatives in the United Nations and the Russian president have persistently outlined the violations by the Ukraine of the ceasefire conditions set out in the Minsk Agreement of 2014 and 2015. Besides, Ukrainian authorities constantly refused to implement the agreements. The necessity to comply with them was clearly mentioned in the United Nations Security Council Resolution 2202 unanimously adopted in February 2015. The need to comply with the Minsk Agreement was outlined during the next UNSC meeting on the matter, including the one held just a week before the start of the Russia's operation. As one may see, here, unlike the situation with Iraq, a binding international treaty did exist. Secondly, United States officials argued about the possibility of preemptive war as a measure of self-defense. The 2002 National Security Strategy of the United States put the argument as one of necessity, an adaptation of the right to self-defense to new circumstances. The relationship of this statement to the Iraq intervention is evident. On many occasions, the United States administration emphasized that it is unacceptable that rogue regimes could acquire weapons of mass destruction because they may distribute them to terrorists. In this context, the terrorist attack of Al-Qaeda in 2001 played a prominent role in the argument of the United States. So, in the eyes of the Bush administration, Saddam's intention to possess and develop weapons of mass destruction, combined with the use of such weapons in the past, called for actions. The international community's views on preemptive war are controversial. As a matter of fact, preemptive war is usually justified as a reaction to a significant, immediate, and unavoidable threat. Such unilateral actions do take place in practice and are supported explicitly or tacitly by a number of countries. They are considered as the lesser of two evils in the light of the difficulty for the United Nations system of collective security to react promptly to the respective threats. So, the international community is cautious and does not assert its total non-compliance with international law. Thus, the 2007 report of the Political Affairs Committee Rapporteur of the Council of Europe stated that a preemptive war is generally considered the narrow outer limit of the self-defense exception to the general prohibition of the use of force. In a more limited fashion, the International Court of Justice has recognized that state survival is a legitimate consideration relating both to the use ad bellum and to the use in bello, if it comes to the use of nuclear weapons. However, when considering the case of Iraq, the lack of evidence that the country possessed weapons of mass destruction annulled the grounds for the United States attacks. As far as Ukraine is concerned, Russian leaders also resorted to the outlined concept. They emphasized that in February 2022, Ukrainian officials intended to annul the Budapest Memorandum on Security Assurances of 1994. This would free Ukraine from its obligations not to possess or create nuclear weapons. This stance seems to be based on the concepts of preemptive war and the ICJ opinion on the possibility for a state to invoke self-defense in case threatening its mere existence. In the absence of weapons of mass destruction, the justification for the Iraq intervention was shifted to the flagrant human rights violations of the Saddam regime. According to this argument, when the violence against one's people goes beyond a certain threshold, the use of force from the outside against the regime may be justified. However, the justification of the Iraq invasion as a humanitarian intervention raises suspicion because this argument appeared after the fact when it became obvious that the other reasons would not hold up to scrutiny. Meanwhile, the mere concept of humanitarian intervention has often been used by states. Thus, preventing crimes against the civil population was one of the reasons used by NATO to justify the Yugoslavia intervention. This interpretation was neither expressly confirmed nor denied by the United Nations Security Council. First of all, the latter refused to adopt the resolution to demand an immediate cessation of the use of force against Yugoslavia. This, according to some experts, signaled a wide political support of NATO's intervention. Secondly, after the war ended with the Kumanovo Treaty, some argued that the creation by the United Nations Security Council in June 1999 of the UN Interim Administration Mission for Kosovo constituted a legal ratification post festum, that is, after the event. So, although the United Nations did not authorize the intervention in a de jure sense, it's argued that NATO's action derived some legitimacy from the UNSC resolutions. As far as the Ukrainian crisis is concerned, Russia's officials invoked acts of genocide with regard to the population of Donbass, namely the military actions against people living there with considerable casualties. Besides, the Russian-speaking population of Donbass was also limited in using their native language and studying it at school, watching television and reading books in Russian. An important point is that Hungary, Bulgaria, and other East European states also condemned the language policy which adversely affected their national minorities living in Ukraine. These concerns were dealt with in an ad hoc fashion and by allowing exceptions to the language policy. For example, the Declaration on the Implementation of the Language Clause of the Law on Education and Guaranteeing the Rights of the Bulgarian National Minority was signed in 2018. The similar understanding was reached with Hungary. The less favorable treatment of Russian language as compared to the European Union languages was also confirmed in 2019 by the Venice Commission of the Council of Europe. The interests of the civil population and the need to stop the discrimination of minority groups were the reasoning behind other international political cases. One of the most recent examples was the explanation surrounding Turkey's intervention in Cyprus to protect the interests of the Turkish community, which was deprived of its rights to participate in the country's policy contrary to the applicable international treaties and constitution. Once it was done, the intervention affected not only the citizens' human rights, in Turkey's view, but also the status of the Cypriot government as a legitimate representative of the whole state. This was also the trigger by which the Turkish community started to voice its right to self-determination. Though Security Council resolutions have condemned certain events that took place on Cyprus, they have consistently recognized that in the context of negotiations between the two Cypriot communities, they should interact on an equal footing. Thus, the United Nations accepted the Turkish Cypriot community's right to determine its political future. Meanwhile, in May 2022, Cypriot President Nikos Anastasiadis noted that Russia's operation in Ukraine uses the exact same arguments that Turkey used to invade Cyprus in 1974. As far as Donbass is concerned, the non-compliance by Ukraine with the ceasefire regime and the legislation limiting the use of the Russian language were the main reasons stated by Russian officials to explain Russia's initial recognition of the independence of Donetsk and Lugansk. The military support it provided them with the framework of the special military operation and the organization of the respective referendums. Besides, taking into account that Donetsk and Lugansk people did not take part in the presidential elections in Ukraine after the coup d'etat in 2014, the current president of Ukraine is deemed as not duly representing the inhabitants of these regions. The Russian government's positions also takes into account the alleged evidence of the United States' involvement in the Ukrainian crisis, including the public statements of the United States official. The Russian government now sees Ukraine as a so-called failed state that lost sovereignty over all of its former territory. And this led Russian government to the conclusion that Russian-speaking people inhabiting regions of Ukraine that historically belonged to Russian Empire and Soviet Republic constitute a people having the right to self-determination on the Ukrainian territory. The human rights violations against this population, as well as the presumable failed state status of Ukraine, suppose that the only way for Russian people to exercise this basic international law right is to declare independence and further decide their own destiny without the participation of Ukraine. Regarding the international consequences of the interventions discussed, the following cases that turned out to have no legal grounds should also be brought to light. Thus, the intervention of the United States into Grenada in 1983, which was explained in particular with the construction by Grenada of the commercial airport that could allegedly enhance the Soviet and Cuban transportation of weapons to Central America. A similar resolution, it was in United Nations resolution called as a flagrant violation of international law. And a similar resolution was also adopted after the invasion of Panama. Eventually, the United States faced no legal consequences other than moral ones. The intervention organized by Turkey also did not lead to any substantial sanctions. In the case of Russia, we see that the international community's rhetoric within the United Nations in particular is not focused on analyzing all the stances and relevant evidence. Aside the arguments on the violation of the ceasefire, the Ukrainian intention to withdraw from any deals prohibiting it from possessing nuclear weapons, and the violence against the Russian-speaking community of Donbass. Russia also argues that Ukraine de facto lost its sovereignty because its leaders received binding instructions from the United States, which led to it accepting to accommodate American weapons on its territory. This leads to the conclusion that Russia's actions protecting the Russian-speaking population in Ukraine are no less legitimate under international law than the ones of the United States in Iraq or NATO in Yugoslavia. Nevertheless, the consequences of the Ukrainian crisis for Russia are truly unprecedented. This means that politics have started to take precedence over international law. Thank you for your attention.
Thank you, Mr. Bunik. Very interesting presentation. I have to recognize I have very different point of views from many aspects that you said, but it's the subject for our discussion. Yeah, so I will invite the participants, dear professors, dear students, if you have some questions, please, it's the time to address them. Please, lady in red.
Over there.
Over there, in red. Afterwards.
I have a question for Mr. Bunik. I'm sorry, it's a little bit chaotic maybe. I even made some notes. So I think I kind of skipped that part, how exactly Ukraine was threatening Russia. It's not clear for me. And the other question is the preemptive war. I studied international law and must have skipped the class when we've been discussing that issue, because I know that the military act is allowed only under two conditions: self-defense, and if it's in accordance with the United Nations resolutions. Okay, let's say that there was some kind of self-defense, and let's say that Ukraine was somehow threatening Russia, which is not clear for me. But then there is a question of proportionality, because even self-defense must be proportional. So if the thing is the language issue, the genocide, I really would like to hear some examples of genocide of Russian population in Ukraine. And what else? Not respecting the Minsk Agreement. I don't understand how it's threatening Russian integrity exactly. And also developing of nuclear weapon. There are other countries developing nuclear weapon like India. Why not to attack India then? Why not to attack the US? Russia shares the border with the US, by the way. So these are my questions. First of all, the preemptive war, let aside all these examples, Iraq, NATO aggression against Yugoslavia, because this is all very questionable and there are very different views on all of those issues. And let alone history, because I mean, let's just attack everyone, like every country where our people lived like some 100 years ago. The world gonna be chaos, in my opinion. I hope not only in my opinion. So my question is, how exactly Ukraine was threatening Russia with the language issue and nuclear weapons, and what are the examples of genocide? And also, yeah, I would really like to hear, because you kind of mentioned how the UN exactly allows this preemptive war, because I cannot recall something like that. Thank you.
Thank you. I will ask the speakers to note the questions, because we'll ask everybody to put the questions, and after that, the speakers will have a chance to answer. Now, Professor Flavier, je vous invite après Monsieur Biago, voilà, Monsieur le recteur. Et, ouais.
Donc, c'est bon, oui. Donc, j'aurais juste quelques... Alors, beaucoup de choses ont déjà été dites, donc je serai... mes questions s'adressent à Monsieur Đukić. Question, observation, où vous avez, concernant le Kosovo ou d'autres situations, vous avez parlé... j'ai l'impression que vous généralisez beaucoup, c'est-à-dire que vous parlez de la reconnaissance des États membres de l'OTAN du Kosovo. Il y a des positions différentes quand même, je crois, dans l'OTAN. Donc, l'Espagne n'a pas la même position, la Roumanie non plus, et la Slovaquie. Enfin bon, bref, il n'y a pas d'unanimité. Donc, je trouve étonnant de mettre cette unanimité-là, alors que justement, s'agissant d'une question qui est très importante, en particulier ici, pour le coup, il y a, me semble-t-il, des différences. Première remarque. Deuxième remarque, il s'agit de la comparaison que vous avez faite, qui est très intéressante, mais qui m'a étonné dans le sens où vous l'avez faite, c'est-à-dire comparer la situation de l'Irak et de l'Ukraine, mais en mettant en avant la question de l'intervention américaine. Si on peut comparer la situation de l'Irak et de l'Ukraine, il s'agit de la question de l'agression américaine en Irak et l'agression russe en Ukraine. Mais parler de comparer les deux situations en mettant en avant le fait que ce sont les Américains qui sont un petit peu les auteurs de ce qui s'est passé en Ukraine, c'est un peu étonnant, parce que autant pour l'Irak, on peut comprendre, autant pour l'Ukraine, je suis étonné que vous ayez fait cette comparaison. Donc voilà, si vous pouvez en parler un peu plus. Et enfin, une dernière chose, s'agissant de la position russe, hein, que vous avez présentée, la position russe qui est variable, hein, qui en 6 mois a changé sur les raisons de l'intervention. Elle évolue, elle est fluctuante, mais vous en avez cité une qui est celle de l'article 51 et des républiques de Donetsk et de Lugansk, du droit à l'autodéfense, à la légitime défense, pardon. Et la Russie qui aurait assisté Donetsk, Lugansk à se défendre contre l'Ukraine. Mais alors dans ce cas-là, une question très pratique, parce que le droit, ce qu'il y a d'intéressant aussi, c'est de revenir, comme on dit en français, sur le plancher des vaches, c'est-à-dire à des choses concrètes. Dans ce cas-là, s'il y a une question de légitime défense, pourquoi avoir été à Kiev? Pourquoi avoir été à Kharkov? Pourquoi avoir été à Kherson? La légitime défense, elle concerne, selon la position russe, Donetsk, Lugansk. C'est la position. Mais dans ce cas-là, pourquoi? Sur la base de quel fondement vous pouvez avancer cela? Le fait d'aller ailleurs que défendre ces républiques comme ce qui est avancé. Voilà.
Si, Hugo, c'est de la géopolitique, qui est sujet de la géopolitique et qui est l'objet de la géopolitique. Mais je vais commenter plus tard. Maintenant, monsieur le recteur.
Sad ostaje ovdje, nikom ne da. Actually, I would be very brief, and I would first address the organizers. Namely, it's kind of regrettable that we do not have Ukraine representatives participating in this conference, and I wonder why they were not invited. We have now a Russian representative who was defending the position of the aggressor in this intervention, and we do not have his opposite. So I'm pretty sure that provided the other side was present here, we would have wider scale of comments and approaches presented to us. The other issue is based on the statement that the Turkish intervention in Cyprus was illegal from the point of view of the international public law and triggered by the desire of the Republic of Turkey to protect the Turkish minority living in that country. I would take this opportunity kindly to remind you that there is a treaty between United Kingdom, Greece and Turkey signed in 1960 when Cyprus was given its independence, and that treaty authorized both sides, Greece and Turkey, to intervene provided their interests in the Cyprus are in jeopardy. And it did happen in 1974 when in Cyprus a coup d'etat was conducted and the enosis, namely unification with the Greece, was to be proclaimed. That was the trigger for Turkish intervention. Having said that, I do not approve it. I just want to remind you that there was a treaty allowing Turkish intervention. What they did, how did they occupy 1/4 or more of the Cypriot territory, and why it didn't change for so many years, that's the different issues. But we should be very careful if we start making such comparisons as a motive to legitimize another intervention. The topic of this conference is the Ukraine and the aggression into Ukraine rather than something that happened half a century ago under different circumstances. Thank you.
Thank you, Mr. Rector
Perhaps-
and Mr. Professor
Yeah,
Begovic.
perhaps we can give now an opportunity for response, and then we will do another round.
Yeah. Okay. Okay.
Okay, so thank you for your questions. And just at the very beginning, I would like to remind you that I started my presentation with a remark that my goal here is not to defend any political position or justify any party's actions, but on the contrary, to reveal the bias surrounding the legal interpretation of events. So your questions, First Lady, so it was, I consider them not to be questions. I consider them to be expression of your position that, namely, there was no genocide in Ukraine, according to your point of view, and that
Please wait because of the translators. No. You cannot respond like this. You can have a second round of answers, but not like this.
Yeah, so as I understand your stance, so you think that Ukraine did not pose any threat to Russia from a military point of view. And well, I do understand your position, and I respect it. But here we should remember that unfortunately, when armed conflicts happen, sometimes, and most of the times, politics do prevail over international law. And unfortunately, this is the situation. So I started my presentation referring to Iraq, not because I think that Ukrainian crisis is justified by the same reasons as the invasion to Iraq. It was because I wanted to show you that while we have these armed conflicts, the explanation may be evolving. So first argument may be different from the second argument and the third argument. And only after time passes, so in history, we can, when we have the possibility to look over the period of time, we can understand which arguments were viable and which were not. So this is regarding the comparison to Iraq. Of course, also, when we had our meeting yesterday, the esteemed professor mentioned that, as I understood him, that actually this is a positive thing somehow, that still, while these awful events happen, still we can, we try to make references to international law. So whether these references are negative or positive, but still we try to find some kind of arguments to justify actions of one party and the actions of another party. Because, well, here, if we speak about the politics, I'm just a lawyer, so I don't have major profound knowledge of political science, but to me, as I understand it, my colleagues who are experienced with international politics may amend me and correct me, but so the thing is like easy, which is at the core of this conflict. And the core of this conflict is actually the NATO expansion. And Russia believes that the expansion of NATO is actually, it is an existential threat to Russia. So it was outlined many times and for a very long period of times that Russia perceives the Ukrainian coup d'etat and its intention to join NATO as an existential threat. And so this is the situation. So what can be done next? So if in my speech I referred to United States intervention to Grenada in 1983. So as you may remember, the reason was because Grenada tried to build an airport which could accept Soviet planes. And so the United States thought that this poses a threat to their national security. And they started military actions there. So, and thank you very much for your comment on Turkey. Yes, I completely agree. So there was this contract agreement between parties, and we also should make reference that to the agreement which was signed between Ukraine and United Kingdom and Russia when Ukraine transferred its nuclear weapons. So this agreement guaranteed the sovereignty of Ukraine. So in this respect, it's somehow can be similar to the Turkey situation regarding Cyprus. Thank you.
The new round.
Mr. Bregovic.
Thank you very much.
Yeah.
Yeah, okay. Thank you very much, Nina, and thank you very much, Gasha, for your two presentations, both of them brilliant. But I'm not a lawyer, I'm an economist and historian in attempt, so I will build up on Nina's presentation. And a few months ago, there was an article which I was pretty puzzled with in Serbian press about Nikolai Gogol, about fierce arguments that Nikolai Gogol is not Russian, that he is Ukrainian writer, and so on, so on. So it was a bit strange to me to consider Gogol, wherever he was born, on which territory he was born, to consider him as Ukrainian writer. After all, it was Dostoevsky, who is still Russian author, I think, who said, all of us grew from Gogol's overcoat. All of us, meaning him, Turgenev, Lev Nikolaevich, and so on, so on. So I'll come back to words of American historian of Russian origin, obviously, Stephen Kotkin, quite a Russian name. And his statement, Russia is not a country, Russia is civilization. And in long-term considerations of Kotkin, I think that he's right. And I think that Nina demonstrated to the great extent that that is right. But one thing is Russia, the other thing is the Russian Federation. So we today talk about the Russian Federation, about the country. And the Russian Federation is the country who violated 3 international agreements. I have all 3 of them in front of me. One is Bielovesia Agreement, for short, from 1991. The other one is Memorandum in Budapest from 1994. And the third one, very important, is a Treaty of Friendship, cooperation and partnership between Ukraine and the Russian Federation. All 3 of these agreements stipulated territorial integrity, sovereignty, and within existing borders of Ukraine. Now, lawyers would say, well, the memorandum, this is not agreement, and so on. So this is sanctions, restrictive measures, whatever. Okay. But I will talk about political economy, because it was Russian political elite who benefited from all three agreements. The Belovezh agreement was dissolution of Soviet Union. It was the way for Russian political elite to run big country, big capitalistic country, to get rid, in short, to get rid of Gorbachev and socialism. And on the fringes of it, to remain the permanent member of the Security Council and to be legally nuclear power. 1994 memorandum allowed Russian political elites to be the only country of the former Soviet Union with nuclear arsenal. And Treaty on Friendship and Cooperation with Ukraine and the Russian Federation had a twin agreement, and that twin agreement is division of Black Sea Fleet of the Soviet Union and the lease of Sevastopol military port. Now, taking into account that history of violating agreements to the benefit of a political elite, in economic terms, taking assets without liabilities, my question to whoever is, who will trust Russia when next agreement is signed? Whatever that agreement will be. Thank you very much.
You give me, if I may.
No, he will give you the floor.
Yeah, Milos, please, and afterwards,
It's fine by me.
lady.
I'll go back to French, if you don't mind, and it will allow me also to try to give an answer to my dear colleague Hugo Flavier. And since I have, it will be a comment, not much a question. Donc,
French or English?
French. Je ne sais pas qui va pouvoir... Alors, d'abord, pardonnez-moi. Merci beaucoup pour votre contribution, Monsieur Đukić, et merci de venir à l'Université de Belgrade et à la Faculté de droit. La question posée par notre cher collègue, professeur Begovic, qui pourra à l'avenir croire la Russie, pourrait être posée à toutes les puissances de ce monde. Les États-Unis, la France, peut-être même la Chine, encore que elle n'a pas fait les choses qui ont été faites par le passé par les grandes puissances occidentales. Nous, les Serbes, on pourrait poser beaucoup de questions sur la crédibilité des grandes puissances occidentales, puisqu'on a une résolution du Conseil de sécurité qui n'est pas appliquée, qui est violée de manière flagrante par ces mêmes puissances. Je parle de la résolution 1244 du Conseil de sécurité des Nations Unies, qui insiste sur l'intégrité territoriale de la Serbie, et qui même comprend une disposition selon laquelle l'armée serbe pourra revenir au Kosovo. Et quand on pose la question à nos partenaires en Occident, on n'a aucune réponse. Donc cette question est valable, mais elle est valable pour plus ou moins tout le monde. Et merci Monsieur Đukić pour, en fait, finalement, vous avez dit la chose fondamentale. On a beaucoup parlé de droit international, enfin beaucoup, de manière conceptuelle, on n'est pas rentré dans les dispositions pertinentes, je le ferai, et je ne vais pas empiéter sur mon propos de tout à l'heure. Mais c'est fondamentalement, la crise dont on parle est fondamentalement une crise géopolitique, ni plus ni moins. Et la cause de cette crise, et ce que vous avez dit, c'est l'expansion de l'OTAN depuis les années 90, la fin de la dernière décennie et les premières décennies de ce siècle, les années 2000. Alors, on peut être d'accord ou pas d'accord sur la réaction de la Russie, qui a dit maintes reprises qu'il était en désaccord total avec l'expansion de l'OTAN, et que c'était d'ailleurs contre les promesses qui ont été faites à Gorbatchev et plus tard à d'autres personnes. Laissons ça de côté. Qu'on soit d'accord ou pas d'accord, il est un fait, c'est une réaction assez usuelle et habituelle pour les grandes puissances. Donc on pourrait critiquer la Russie si c'était la seule à ne pas vouloir ce qu'elle considère comme étant une menace à ses frontières. Sauf que vous avez parlé de Grenade, on aurait pu parler de la crise de Cuba, mais on va dire que c'est assez éloigné de nous. Je vais vous donner un exemple beaucoup plus précis et beaucoup plus proche de nous. C'est le fameux accord d'avril, il date d'avril de cette année, hein. L'accord qui concerne les îles Solomon et la Chine. Alors les îles Solomon, c'est le Sud-Pacifique, hein. Ils ont conclu un accord qui n'est pas fondamentalement un accord de sécurité, qui permet aux bateaux chinois de se ravitailler, de faire éventuellement de réparer des dommages, etc. C'est pas une base navale, c'est rien du tout. Alors cet accord assez simple, donc on ne parle pas de l'OTAN aux frontières, cet accord assez simple a suscité un tollé, a soulevé un tollé en Nouvelle-Zélande, en Australie et aux États-Unis, qui voient tous ces États, tous, une menace pour leur sécurité, pour les intérêts, ils le disent de manière très claire, explicite. C'est une menace pour leurs intérêts dans la région Sud-Pacifique. Alors là aussi, on peut être d'accord ou pas d'accord, mais c'est un état de fait. C'est comme ça, c'est la géopolitique, et c'est une question avant tout géopolitique, et ça va se régler, qu'on le veuille ou non, par les armes. Tout ce qu'on peut dire, le droit est là, le droit pose des limites, je vais en parler de manière très claire. Il y a viol de ces limites, de ces dispositions, que ce soit le recours à la force, ou plutôt l'interdiction du recours à la force, que ce soit l'intégrité territoriale, que ce soit le droit à l'autodétermination. Tout est violé, mais ce n'est pas nouveau. Et vous avez finalement, d'une certaine façon, rappelé, vous nous avez rappelé, que, encore une fois, malheureusement, j'allais dire, une tradition de violation du droit international, et ce, de ces normes impératives, donc des normes de jusqu'aux-gens, faites par la Russie, faites par la France, faites par les États-Unis, faites par l'Allemagne. Et quand son Excellence, l'ambassadeur de France, Pierre Cochard, parlait hier de... Alors j'allais le citer tout à l'heure, je le citerai, je le reciterai. Je l'ai quelque part là dans mes papiers. Il a dit, en somme, l'invasion russe est en train de démanteler le droit international. Peut-être, mais il a commencé à être démantelé bien avant, en 99, en 2003 avec l'agression contre l'Irak, etc., etc., etc. Bon. On parlera de droit, il faut parler du droit, c'est important, il existe, et je dirais qu'il existe. Il n'a pas les fonctions qu'on attend d'un droit, mais il existe, mais c'est fondamentalement une question géopolitique, et je ne suis pas certain que la responsabilité principale dans cette question réside du côté de Moscou. Je tendrais à dire qu'il est plutôt à l'ouest, mais ça, c'est mon opinion personnelle, et je ne m'avancerai pas davantage là-dessus. Merci beaucoup.
Merci Miloš. Et après ça, on va la parole. You have a question? Or comment? I have also a comment.
Thank you very much, Mr. Bunik, for your intervention. And unlike my colleague Miloš, I will speak from the legal point of view. And thank you for emphasizing that you are here to emphasize the legal points and not political ones. I was teaching international criminal law for several years, and I have two questions for you. The first regards your totally correct remark and intervention, and I could not agree more with you when you pointed out that in 1999, NATO unlawfully, without authorization of the Security Council, bombarded Serbia. Quite well, and I agree. But if you can tell me which international instrument and in which article allows that because of this, Russia could invade and conduct aggressive war towards Ukraine? Or could any other state invade other state because NATO unlawfully bombarded Serbia? This is one question. The second question regards to allegedly committed genocide against Russians in Ukraine. Okay, but according to the UN Genocide Convention, which article allows Russia to invade Ukraine and to conduct aggressive war in order to stop or prevent genocide? Thank you very much.
Thank you, and maybe you do not have at this stage some questions. We'll ask Ivan to answer to this question, and afterward I have a brief comment, and I will intervene after you answer to the questions.
Okay, so I'm sorry, but again, we have to repeat what I told during my presentation. So we analyzed different positions which like make connections between international law mechanisms and military interventions. So I explained that in the history of these armed interventions, normally is especially of such waste, such waste and huge interventions. So we cannot, like, of course, outline. So this is the reason, and this is the legal reason for the invasion. Because if it could be this way, so I guess maybe we did not gather here to discuss it. So there was a reason for the invasion, and there is an article, yes, in the United Nations Charter, and Russia's actions are legal and in compliance with international law. But at this moment, I repeat, in my opinion, it's not possible to justify Russia's actions with picking up and pointing to a specific rule in international law. So it's not possible, and it doesn't make. We cannot, like, because of this, we cannot say that these actions are not compatible with international law, because we can say this and we can say otherwise, because as was put by one of scholars, I think maybe he was cited yesterday. So when states consequently do something that violates international law, international treaties, so an international custom may arise. And as we know, international custom is has the same legal force as international law, which is in material form, yes, like a treaty, a charter, and so on. So I repeat that the justification for military actions, it is evolving procedure. So it's not possible to say that we have one legal rule and this rule is the reason for military actions. So that is not possible. But during our discussion, I would like to put participants' attention to the fact that normally here the situation is much more complicated, that simply there is a sovereign state of Ukraine and there is a sovereign state of Russia, and simply there is invasion one day without any underlying reasons. So this problem, it existed a very long time. Even as you know, the Russian writer Solzhenitsyn, who is well known, so he predicted that this conflict would emerge sooner or later, and he did it like 40 years ago. So he told that this is like intangible conflicts here, and Nina's presentation gave us the idea what is the problem there, because yes, you see, so when it was the Soviet Union, so these were not international borders between Russia and Ukraine. These were borders between administrative borders in the same state of the Soviet Union, and that's why. So they tried. They changed these borders because of some. These were artificially created borders by Russian communist leaders, and we see from the history of population that indeed there are like Russian-speaking population and Ukraine population, and they are very much mixed in this area, which is a territory of Ukraine after the dissolution of the Soviet Union. And so, secondly, there is this geopolitical issue. So we have the national issue and then the geopolitical issue, and they clash together, and we have what we have now because of alignment with the Minsk Agreement. So they didn't want to implement this agreement, and unfortunately, so the conflict spirals and has a risk to spiral out of control, because like Western countries with all their military and economic might, they give support to the Ukraine, and it makes like very difficult solution to terminate the conflict when we have on the one side like United States and NATO countries and the European Union, and on the other side it's like only Russia. We know that the Russian economics is much smaller than the Western economics. So, thank you.
Thank you, Ivan. Maybe I would like to intervene too and to make short comments on different issues. And afterward, I will give the floor to Nina to address the question to our colleague, Professor Popovic.
I just wanted to make a brief.
Yeah, please.
I need a mic.
And there's someone
This.
Okay. Our colleague from Russia has recently said that the borders between Soviet republics, including Ukraine-Russia border, were set by the Soviet government or the Communist Party or the Soviet Union, and that they were in a kind of provisional settlement. They became, however, the international borders by the agreement from Malorossiya in 1991, and so they have been internationally recognized. There is a number of bilateral Ukraine-Russian agreements dating back to the 90s and the early 2000s, which reconfirm the validity of these borders as international borders. You cannot disclaim, you cannot
You can, one floor is working there. Miloš, le microphone de là-bas, il travaille.
I apologize. So one cannot disclaim the validity of the borders that were proclaimed by a government which was a legitimate government of the Soviet Union. We can agree or disagree with the moral values defended in the Soviet Union, but it was for more than 80 years the only state that ran Russia and other republics that are now sovereign states. I cannot agree also with the statement that Khrushchev gave as a gift Crimea and Sevastopol to the Ukraine. It was the decision of a legitimate organ, the Supreme Council of the Soviet Union. And by the way, in 1954, Khrushchev was not the person who was able to decide unilaterally that part of the Russian territory would be given to the other Soviet republic. Please bear in mind that he became the first secretary of the Communist Party only in the second half of 1953, and that only in 1956 he had defeated his opponents within the Politburo. So the decision in 1954 had to be the decision by the majority of the members of the Politburo, not the unilateral decision of the first secretary, very weak one at that time. So this is a propaganda statement that Khrushchev, allegedly a Ukrainian, wanted to compensate Ukrainians for the horrors he and the others did commit against them during 30s, during the Holodomor. No. It was a legitimate decision by an organ, wrong or correct, it's not to me to assess, but I do not agree with the statement that it was a gift of a rogue statesman who had absolute control over the Politburo. He did not have it in 1954. Finally, the decisions of a government do oblige the next governments of a state. So we cannot now disqualify the decisions by a Soviet government from the point of view of the existing one, because that was something that the Bolsheviks did try in 1918 when they were denying all the obligations taken by the Tsarist government. That's not the approach that the international public law recognizes. The approach which that part of our legal system recognize is that the decisions do oblige the governments. And that also applies to the issue of the borders between the republics that used to be parts of the Soviet Union. Thank you.
Thank you, Mr. Rector. So maybe I would like to have some comments on.
Vladimir, there are more questions from the floor.
Ce sont des questions?
Oui, oui, il y en a.
Hello. Oh. Thank you very much for your presentations. My name is Maria, and my question is that we talked a lot about the geopolitics, and we talked about a lot of violators of international law, but because I think we are at the law school, I was wondering if someone can comment what is the legal recourse to address Russian aggression on Ukraine. Thank you.
Yeah, okay, thank you. So I will try. If I will not be able, maybe my colleagues will ask me. Yeah. So, firstly, I would like to have a comment on beginning with Mr. Begovic question, rhetoric question. Who will believe Russia when it will try to conclude another agreement? And I will have maybe a short intervention about the Donbass status as in the field of presentation made by Mr. Popovich. But making this short comment, I will come back in the history with some 20 years, and I will make a parallel with my country. Yesterday, I spoke about the Transnistria issue, and please pay attention. In 2000, so Transnistria conflict exists since the beginning of the Republic of Moldova and since the crushing of the USSR in 1991. So the conflict was for more or less more than 10 years, and in 2000, all the political powers in Moldova tried to solve this conflict. Surely they applied to the Russian Federation, firstly. In 2003, Mr. Kozak comes to Chisinau. Mr. Kozak was at that time the president of the chief of president administration, of Mr. Putin administration, 2003. Russian Federation was proposing to us a so-called memorandum, Kozak memorandum. Two issues very important in this proposal: that Transnistria had a quota in the national parliament of Moldova. We have 101 members of parliament. And Kozak proposed that in that parliament, Transnistria had a quota of 15 members of parliament. It's not the most important. The most important it's now. But they had the right to veto any right of parliament and of Moldova in its foreign policy. I translate. So the Transnistria, if Moldova would accept such a proposal, the Transnistria would put a veto to Moldova European Union integration and to put a veto to Moldova to decide the issue of integration with Romania, because we are the same people, but we live in two countries. And we have a part of the people in Moldova which are, have this option to be united with Romania. But it's not the most important. So the most important that the Russian Federation tried to intervene and to impose an issue, so a control of Transnistria over all the foreign policy of the Republic of Moldova. And the next point, what was in the memorandum of Kozak, it was that the Russian army, which is staying illegally in Moldova and Transnistria, according to this proposal, a Russian army would continue to stay indefinitely. So, from my point of view, the Russian army, which is staying now, so it's an occupation, and it's illegal, and the Russian Federation authorities do not find anything illegal here in this issue. So, I come back with this memorandum, Kozak memorandum, I come back to Mr. Begovic rhetoric question. Who will believe? Moldova will not believe, because it's very hard to believe Russia, and when it proposes some kind of special status for different regions, autonomous regions, or other special status for different regions in different countries. Our professors from Moldova were discussing the issue of federalization of Moldova with German professors, constitutional law. So for Germans, a federalization is very usual, so it's very good subject of discussion. In Moldova, no political party can use this concept, very good concept, but it cannot be used in Moldova because everybody knows that Russia is trying to put its influence through this concept of federalization. And I come back to Donbass region. It's the same. Russia is trying to ensure this kind of independence or special status, autonomous status for Donbass and Lugansk region with special purpose to influence Ukraine through these autonomous, special autonomous regions. It's not a critics to you, it's a critics to, or it's analysis of Russian Federation foreign policy towards us, neighbors. And I will agree with Milos, who said that firstly, we are talking about geopolitics. I'm a lawyer, I'm not a professor in political policies, but firstly, we are talking about geopolitics. Why? But because in your presentation, you said Russian Federation authorities do not see a subject of international relations in such countries like Ukraine, and such countries like Moldova and other neighbors. We are not subjects for us, for Russian Federation. We are objects. And Russian Federation always treated and Moldova and Ukraine like objects. And in your presentation, it's very evident. Russian Federation is trying to talk with NATO, with United States, with European Union about Ukraine. Not with Ukraine about Ukraine, but with NATO, United States about the fate of Ukraine. It's geopolitics, but geopolitics do not annul international law. I totally agree. And if you come back in the field of law, we are talking about sovereign states. Why the sovereignty of Ukraine, Moldova, and other countries is annulled because of geopolitics? No. So the content of sovereignty of Ukraine, of Moldova, it's not shorter, or it's not more limited than comparing to the sovereignty of our states. So this is the point. So let's treat every state with equal treatment, so equal content of sovereignty, sovereign rights. And you said about genocide in Donbass, and that was one point, one reason for the intervention of Russian intervention. So sorry, in these regions, Lugansk and Donetsk, they, you know better than me, they organized so-called authorities. And they have such kind of so-called authority, ombudsman. And if you will read the reports of ombudsman from Lugansk and Donetsk, not recognized by Ukraine, but Russia should believe in these reports. According to these reports, from 2014 till 2022, there was 5 or 6 killed persons. 5 or 6 killed persons during the in the framework of these clashes between Ukrainian forces and Lugansk and Donetsk forces. So 5 or 6 killed persons, it's far from the concept of genocide. It's very far. So you compared aggression, or not you, but you compared, but and the Russian authorities also are comparing the use of force against Yugoslavia, use of force against Iraq, and use of force of Russian Federation against Ukraine. Sorry, but it's totally different in my opinion. So after 1945, there is no single example when a state annexed a foreign territory, Crimea, by Russian Federation. And now this annexation with Kherson, Zaporozhye, Lugansk, and Donetsk is the next story. So no United States annexed the territory of Iraq, and no NATO or United States annexed the territory of Yugoslavia. But I do not want to tell that it was not an aggression. So, and Article 51 of the Charter, Article 51, it's not applicable here, because you will not find in the Article 51 the right to a preventive attack. There is not such right in international law. So the Russian authorities are using, so it's destroying this, the content of Article 51. So the right to people to autodetermination, it's false, because in Donbass, we are talking about people, not population, and the framework of this right. And we have population there. We do not have only Russian people. We have Ukrainians, we have Russians in those territories. We have a lot of... Oui, voilà. S'il vous plaît.
Je vais le faire en français. Bonjour. Bonjour à tout le monde. Bună ziua. Je suis Dušan Gujanić et je suis doctorant en droit international à la Faculté de droit à Belgrade. J'aurai deux questions. Je vais essayer d'être assez bref. L'un pour monsieur Đukić, si je ne me trompe pas, et l'autre pour monsieur Grosu, excusez-moi. Ah, d'accord. D'accord. D'abord, je dois constater à haute voix qu'il est terriblement difficile d'être objectif, totalement objectif dans ce sujet parce que vraiment plusieurs aspects sont inclus ici. D'autre part, pour ne pas être trop long, je vais laisser encore de temps à d'autres intervenants. Pour M. Đukić, d'abord, je dois constater que je peux comprendre humainement et politiquement le besoin de protéger sa propre population en dehors des frontières étatiques. Et en général, je peux comprendre donc, ce besoin, je dirais, historique, moral, constitutionnel, comme vous voulez. Mais je m'adresse à vous directement en tant que juriste. Est-ce que si vous étiez en situation de protéger, vous, la population russophone aujourd'hui, est-ce que vous choisiriez la même voie? En d'autres termes, n'aurait-il pas été plus pertinent pour l'État russe, à la fois du point de vue politique et juridique, de concentrer ses efforts militaires uniquement, je souligne uniquement, sur la région de Donetsk et de Luhansk? Et sur ce point, je rejoins la remarque de professeur Flavier. Donc, puisque l'argument de proportionnalité joue un grand rôle dans le droit international, comme nous le savons tous. Donc, c'est ma question pour vous. Et la question pour M. Grosu. Ah, ben, est-ce que je peux lui poser une question? Ah, d'accord, d'accord. Bon. Ok, je comprends. Merci en tout cas. Hein.
Non, c'est veto.
Alors, est-ce que j'ai bien compris que vous me demandez si j'étais le président russe, quelle serait ma décision?
Si vous voulez, oui, oui, oui.
Oui. Alors...
Mais je vous ai posé la question en tant que juriste. Hein.
Oui. Du point de vue juridique, et maintenant je dois faire une réservation importante parce que c'est mon avis personnel juridique. Je ne peux pas faire des commentaires concernant les actions de l'armée russe parce que nous avons même dans la télévision pour un peu vous amuser, je vais citer l'un des gens qu'on appelle les repères de l'État, ces gens des propagandistes qu'on les appelle. Une fois, après les disons, soit retrait, soit mouvement militaire autour de la ville de Kherson. Alors, il a dit pendant cette émission politique, je ne sais pas ce soir qu'est-ce que faire, parce que si nous allons commenter ce qui se passe à Kherson, si je dis d'une façon, c'est la violation dans tel article du code pénal russe, comme je critique l'armée russe. Et si je dis d'autre façon, ce serait une autre crime selon le code pénal parce que ça va dire que je soutiens la cessation du territoire russe. Oui, alors c'était même pour les gens à la télévision le problème. Et si je n'ai pas des ressources pour être plus inventif que eux. Mais mon avis personnel, disons, ce serait que peut-être du point de droit international, ce serait plus facile de faire les choses d'une façon n'est pas si vite que c'est passé. Les référendums avant que la lutte militaire finisse, c'était trop vite, à mon avis, parce que je pensais que peut-être ce serait plus raisonnable faire ça pas après pas. Alors, regardez la réaction, mais je pense que peut-être les raisons ne sont pas, répétons-nous, premièrement, légales. Oui, les raisons ne sont pas légales. Les raisons pour les actions du gouvernement russe, ils résident sur la situation politique, la situation militaire, et ils doivent faire les choses de telle manière qu'ils pensent est correct. Alors, ça, c'est mon avis. Merci.
Thank you. Mr. Popovich, if you can answer.
No, because the lady who posed the question went out, so there is no use answering. If she returns, I'll take the question.
Okay.
I suggest you give the word to me.
So we suspend.
Can I answer to the others?
Yeah, Nina, and afterwards somebody who is there.
Okay, thank you. I'll try to be quick. To Professor Popovich, I think there might have been a misunderstanding of my use of the map there, because I explicitly stated that the phrasing of those things as gifts of those leaders was misleading, that I don't agree with that. With that phrasing. So those who are saying that, yes, of course, but I was just pointing out that the map showed which were the territories involved and when which change happened. But the thing that I wanted to point out with Crimea is that it had been a separate autonomous republic until 1954, and in 1991, when the Soviet Union started falling apart, it initiated a procedure for becoming an autonomous republic once again, and over 93% of inhabitants of Crimea voted in favor on a referendum, but that procedure was never completed, and Ukraine had the borders that it had had in the Soviet Union. So I was just implying that had that procedure been complete and Crimea separated from Ukraine before Ukraine gained sovereignty, perhaps things could have ran a completely different course. To Professor Begovic regarding Gogol, very briefly, though I'm not an expert on literature, but the way I see it, yes, of course, he can be and should be seen as a part of Russian culture, Russian generally, but he is also very much considered to have the roots of the Ukrainian or Malorussian, as they would have put it in that time, mentality. He uses many folk motives from that area in his writing and so on. So we have elements of both identities, but of course claiming that he's Ukrainian and not Russian is absurd. And as for your rhetorical question, who will trust Russia? Well, those who trusted Russia previously will keep trusting Russia because they see the actions of Russia in this war as overall legitimate. Some of them even think they're legal, some think they aren't, and that Russia should have chosen a better way, but that it is protecting its legitimate interests. Those who are already Russia's opponents in this or some other recent conflicts haven't trusted it to begin with and haven't trusted it since the Middle Ages and aren't about to start trusting it. So generally, I think when we're talking geopolitics, long-term rivals don't trust each other, whatever they sign. So
in terms of dynamics, the number will go down, to put it in this way. It's end to end.
In Europe, quite possible. In Asia, in Africa, it might go up. So yes. I'll stop there to save time.
Thank you, and well, please, Professor, take the floor.
Bon, je peux poser la question. Oh, okay. I will speak in English. Okay, okay. Don't take off your your headphone. Okay. I would like to ask the Russian colleague because he spoke a bit of it, and we heard at the beginning of the war the explanation of the reasons for the Russian intervention in Ukraine. They invoked the right of self-determination of the peoples of Donbass, of Donetsk and Lugansk republics, and the help that was brought by Russia to them in their legitimate defense according to Article 51 of the UN Charter. So I guess that is the reason for which Russia recognized first, several days before the beginning of the intervention, the independence of those republics. So I would like to quote something in order to speak strictly in legal terms. There are several documents that speak about that, and I would like first to make a short quotation of the Declaration on Principles of International Law concerning Friendly Relations and Cooperation among States in accordance with the Charter of the United Nations. I have to draw attention to the fact that this is an interpretative declaration. So although it is a declaration, it draws partly its strength from the document it gives the interpretation of, and that is the Charter of the United Nations. So it speaks about the right of self-determination and territorial integrity, because both are protected by the UN Charter. And it says nothing in the foregoing, perhaps paragraphs shall be construed as authorizing or encouraging any action which would dismember or impair, totally or in part, the territorial integrity or political unity of sovereign and independent states, conducting themselves in compliance with the principle of equal rights and self-determination of peoples, as described above, and thus possessed of a government representing the whole people belonging to the territory without distinction of any kind. So it is repeated in the two other documents, one document of the Conference on Human Rights, World Conference on Human Rights in 1993, and another similar declaration from 1995. All of them were accepted by unanimity by all the members of the United Nations. So that is okay. I will read now a paragraph from the Supreme Court decision of the Canada concerning the secession of Quebec, whether Quebec had the right to external self-determination, so meaning secession. And the paragraph 138 states, in summary, the international law right to self-determination only generates at best a right to external self-determination in situations of former colonies. So this is not a former colony, where a people is oppressed, as for example, under foreign military occupation. So this was not foreign military occupation, or this is the third situation which might be applied here, where a definable group is denied meaningful access to government to pursue their political, economic, social, and cultural developments. In all three situations, the people in question are entitled to right of external self-determination because they have been denied the ability to exert internally their right to self-determination. Okay, this is the Canada. And just to explain what could be the acts of depriving of rights that may lead to external determination, I will read a document entitled The Implementation of the Right of Self-Determination as a Contribution to Conflict Prevention, which is in fact a report of the International Conference of Experts held in Barcelona, organized by UNESCO. So also the United Nations Special Agency, so it has a strong value. And it says, and my question to you would be, was anything of this kind happening to Russian people in Donbass? And it says, this is the text, in the broader context of self-determination, separation or secession from the state of which a people forms a part should be regarded as a right of last resort. So the last resort, you have to try other means to solve the situation. I think the Minsk Agreements were something that was the previous resort that didn't work. So thus, if the state and its successive governments have repeatedly and for a long period oppressed the people, violated the human rights and fundamental freedoms of its members, excluded its representative from decision-making, especially on matters affecting the well-being and security of the people. I would like to, especially to ask you what was happening to the parties that were, even that were winning at the elections, like the party of the region, which disappeared from the political scene after 2014, etc. Then, affecting well-being and security of people, suppress their culture, religion, language, also language, I would like to put stress on it, and other attributes of the identity valued by its members. And if other means of achieving a sufficient degree of self-government have been tried and have clearly failed, Minsk, then the question of secession can arise as a means for the restoration of fundamental rights and freedoms and the promotion of the well-being of the people. So you mentioned the genocide. I think the genocide is too far-fetched, but it's not necessary. There is something, let's say, less serious than a genocide could be sufficient as a justification for this remedial secession. So could you tell us, you certainly know better than us the situation in Donbass, was anything of this happening there or not? Thank you.
First of all, I should admit that I do not claim that I know better than you about the situation in Donbass, because, I did not travel to Donbass, I did not speak to local population. I only read media on the subject. I read, of course, Russian sources and American sources and French sources. But here, the right to self-determination, this is a very tricky right, because we should remember that, well, this right balances with the right to preserve the state's territory. And so how to find a balance here? What should prevail? Whether it is a right to self-determination or whether there is the territorial integrity of a particular state. And in my personal point of view, if we like give more force to this right of self-determination, it could be dangerous even for Russia, because you know that Russia is a multinational state, and so then if we admit these legal arguments about the self-determination, so what will be then with these minorities like Chechen people and Buryat people? So every nation can say, I want a separate state, right? And so what will happen to the borders? And also we should remember that now, of course, we have a very strong opposition in Western views to the conflict in Ukraine, and Russian views to its national interests. But we should, in my opinion, think a little bit ahead. So what happens now? So West supports Ukraine with all types of military aid and financial aid. So in this way, the conflict may go to some point of no return. So how should it end then, if there is no possibility to win the conflict by military means? And okay, so what would be consequences, just suppose, if Russia loses this conflict? So what can happen then to Russia? So there is a big risk that it can be like become a politically and territorially unstable, and this would create a further dangers to the whole community, to the whole population of our planet. So I think we should find the solution to this conflict, not like speaking about some legal rights to self-determination, but we have to find a solution which is acceptable for Russia, and which is acceptable for Western countries, and of course which is acceptable to Ukraine. But if we return to this right of self-determination, well, here I think this argument may be used to be discussed within the Ukraine, because as information what I do have is that maybe Ukrainian President Mr. Zelensky also would be like okay with terminating this conflict by signing a peace agreement with Russia, which would maybe provide for some territorial disputes settlement. But as we have information from media, so he cannot do this because he's depending on people in Ukraine, so who would, like he says, not forgive him if he cedes a part of Ukrainian territory to someone. So I think that maybe a discussion should be initiated in Ukraine to explain the history of two people, Russians and Ukrainians, and to explain that this should be somehow resolved. So if Ukrainians like understand this principle of self-determination, maybe we will have some, like let's say, light in the end of the tunnel, when they would like discuss rights of people. So when it would be admitted that actually this problem exists in Ukraine. So it exists a problem, like because what I've read, like interviews with population of Donbass. So after this coup d'etat of 2014, they say that they feel themselves treated like people of secondary importance, so second sort people by the Ukraine, because well, the Ukraine government is not happy with them, so they call them like separatists, and they say you should go to Russia and so on. So thank you.
No, I think we're quite late, and we will have opportunity to rediscuss this issue in our panel. So,
Yeah, Tanasi, please.
Yes, if I can just take the position of the member of the organizing committee, and to, in that sense, response to Professor Popovic at the end of the debate of this first session today. First of all, I would like to thank you for your question, because you were not the only one who posed that question. If there is a Russian here, why there is no an Ukrainian as a member of any of the panels? I have to say that we, as an organizing committee, we took a very good care of the proper balance of the topics and of the interpretations that could come out of those topics with respect to this to the war in Ukraine. Secondly, we did not conceive this conference as a battlefield of different political positions, but as a proper academic discussion based on the arguments. Thirdly, no one is present here as a representative of any government. Everyone who is in the panel is invited in his or her professorial capacity, including our colleague Ivan Bunik from the Moscow State Institute of International Relations. Fourthly, if this is the way Russian academics respond to very legitimate, and more than that, very well argumented critical words on the Russian aggression on Ukraine, then it is for all of us here to assess the value of those arguments, which are obviously used by Russian politicians, and also to assess the academic standards in Russia when it comes to responding to these very serious and very sensitive political questions of our moment. And finally, I can just sum up with using a classical liberal argument of John Stuart Mill. If there was one person who thinks different from everyone else, and that person is wrong, that person has no less right to be heard than everyone else, because it allows everyone else, us, to develop our arguments and to be better convinced in the rightfulness of our positions. Thank you. This is my personal position as a member of the organizing committee to Professor Popovic and other legitimate questions which were put in that respect. Now, another question of organization. We are going to, we have exhausted the questions from the floor. We are going to have a lunch break now. And since we have worked longer in this session, we're gonna resume our work at 3:30. So not 3, but 3:30.